The court has formulated its decision based upon the overriding principles and purposes of felony sentencing, which are to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution. The court has considered the relevant sentencing guidelines provided in 292911, 292912, 292913, as well as 292919. I can't agree more with the parties that Kaden had absolutely nothing to do with this. He is truly an innocent victim. I'm very sorry to his family. It's a tragic loss, and it obviously should never have happened. That being said, the court believes the following sentence is appropriate. As to count 1, aggravated murder in violation of Revised Code 2903.01A, I'm sentencing to a life sentence with eligibility, with eligibility after serving 30 years. The 18-month and 3-year firearm specifications shall merge into the 54-month gun specification. That 54-month gun specification shall run consecutively to the underlying sentence of 30 years to life. Should you be released as to count 1, you are subject to the supervision of the adult parole authority for the remainder of your sentence. As to count 8, attempted murder in violation of Revised Code 2923.02 and 2903.02, a felony of the first degree, that'll be a 3-year sentence at the Lorraine Correctional Institution. The 1, 3, and 54-month gun specification shall merge. The gun specification in count 8 to be served concurrently with the gun specification in count 1. As to count 10, attempted murder in violation of Revised Code 2923.02 and 2903.02A, felony of the first degree, that'll be a 3-year sentence at the Lorraine Correctional Institution. The 18-month and 3-year gun specification shall merge into the 54-month gun specification. The 54-month gun specification in that count shall run consecutively to the underlying 3-year sentence, and to the gun specification shall run consecutively to the gun specification found in count 1. In an abundance of caution, I will advise you as to count 10, you are subject to mandatory PRC if you were to ever be released on that count. That means that you face a mandatory minimum of 2 years up to a maximum of 5 years of post-release control, which means the adult parole authority and not this court would supervise you. They would give you terms and conditions you must follow. Should you fail to meet the terms and conditions of the adult parole authority, then they can modify and or extend your supervision and make it more restrictive, incarcerate you for up to 1/2 the original sentence imposed by the court. If you fail to appear for them, they can charge you with a new offense called escape, another felony, where you face additional prison time. And if you committed new crimes while on post-release control, you could face the maximum penalty under the law for the new crime committed. Because this offense also includes the Reagan-Tokes advisement, I must advise you of the following. I'll note counsel's objection to Reagan-Tokes. As to count 10, sir, you will receive 2 sentences. You will receive a definite sentence up to an indefinite sentence. That means the following. Pursuant to 292919B2C, that there is a rebuttable presumption the defendant shall be released from service of the sentence at the expiration of their minimum term or presumptive early release date, whichever is earlier. That the DRC may rebut presumption if, at a hearing held under 2967.271, DRC makes specified determinations regarding the offender's conduct while confined, the offender's threat to society, the offender's restrictive housing, if any, while confined, and the offender's security classification. That if, as described in Vision 2, DRC at the hearing makes a specified determination and rebuts the presumption, they may maintain the offender's incarceration after the expiration of that minimum term or after the presumptive earned early release date for the length of time DRC determines to be reasonable, subject to the limitation specified in section 2967.271, that the department may make the specified determinations and maintain the offender's incarceration under the provisions described in Division B2C1 and Division 2 of this section more than one time, subject to the limitation specified in section 2967.271. That if the offender has not been released prior to the expiration of the offender's maximum prison term imposed as part of the sentence, the offender must be released upon the expiration of that term. The definite sentence as to count 10 would be 3 years, up to an indefinite sentence of 4.5 years. As to count 14, trafficking in cocaine in violation of Revised Code 2925.03A2, a felony of the first degree, with the specification of major drug offender in violation of 2941.1410A. That will be an 11-year sentence as to the felony of the first degree. The 18-month firearm specification found in that count shall run prior to and consecutively with the underlying 11-year sentence and consecutively to the firearm specifications found in count 1. I will order all the items forfeited in that count to the Cleveland Division of Police, and based upon your indigency, I will waive the mandatory fine. As to count 16, having weapon while under disability in violation of Revised Code 2923.13A2, felony of the third degree, that'll be 3 years at the Lorraine Correctional Institution. As to count 17, possession of criminal tools in violation of Revised Code 2923.24A, felony of the fifth degree, that'll be 12 months at the Lorraine Correctional Institution. Further, counts 1, 8, and 10, and 14 shall run consecutively to each other. And the court believes the following. Court finds that a consecutive sentence is appropriate pursuant to Revised Code 2929.19B2B and 2929.14C4. The court finds that it is necessary to punish the offender, protect the public from future crime, and it is not disproportionate to the seriousness of the conduct and the danger posed by the defendant. That one or more offenses were committed while the offender was awaiting trial on community control sanctions or post-release control, and that 2 or more offenses are part of 1 or more courses of conduct, and the harm certainly caused is so great or unusual that a single prison term would not adequately reflect the seriousness of that conduct. Sir, that'll be a life sentence with eligibility for parole after serving 57.5 years up to 59 years. You will be given credit for 385 days, any days awaiting transport. I will waive again all fees and costs. The first time you're eligible to see the parole authority, to my calculation, will be approximately 91 years old. I will assign appellate counsel at this time. Sir, it's my understanding you do not have money to hire appellate counsel, is that correct?
Correct.
All right, I will assign Attorney Andrew Baker to represent you as an appeal, and I will order the transcript at state expense. Is there anything else we need to do on the record on behalf of the state?
No, Your Honor.
Anything else we need to do on the record?
No, Your Honor.
Mr. Stolze?
No, Your Honor, thank you.